Good morning.
SJC-10994.
Good morning, Your Honors. May it please the Court, Kris Foster for the Commonwealth. With me is the motion prosecutor, Assistant District Attorney Brooke Watson. The defendant interprets Section 72A to mean that every defendant who commits a crime as a juvenile but isn't apprehended until he's at least 18 years old must go through a 72A hearing, and that Section 54 is inapplicable. If the Court adopts this interpretation, the defendants who fall under this category are deprived of a huge range of benefits and protections provided under Section 54.
What does the language in Section 72 say?
In 72 or 72A?
Yeah.
72A only deals with delinquency complaints. I would say that the legislature in 1996 created the 1996 Act to do two things. One, to close all loopholes for juveniles in this situation, and to provide prosecutors with more discretion to prosecute the most violent crimes. The court did this the legislature, did this by creating two avenues. They modified 72A so that it covers all defendants who are apprehended after turning 18. They also created Section 54 to give prosecutors more discretion to prosecute violent felonies. Of course, the prosecution would have to prove that the defendant's a youthful offender, which would mean it would have to be a violent felony, most likely, or a defendant who has already been committed to DYS or who has a prior gun or prior.
So your position is 72A applies only to delinquency cases, and because youthful offender cases aren't delinquency cases, they're not governed by 72A.
I think 72A governs any time a defendant in this situation is going to be tried in district court or superior court. There's a 72A hearing. But a Section 54 hearing also provides the protections of 72A. Of course, as you know, 72A provides for a probable cause hearing and then a determination, if it's in the public's interest, to prosecute this kind of defendant.
Is that probable cause hearing one where the defendant is entitled to be heard?
He is.
And that's different than what a grand jury would do.
I do agree, but that's not where the benefits end for a Section 54 hearing. Under Section 54, in comparison to Section 72A, once the Commonwealth indicts a defendant, he's indicted as a youthful offender. And then he's tried in juvenile court with a juvenile court judge who better understands juvenile crimes. Then, when it's over, he is adjudicated a youthful offender. It's not a conviction.
How does the Commonwealth how does the juvenile court get jurisdiction over someone who's over 18, absent 72A?
I believe it's under the third paragraph of Section 54, where it says the Commonwealth can proceed against a person who, by indictment, as long as they satisfy the youthful offender criteria. There's no age limit.
But the reference by incorporation is only in that paragraph to statutes preceding that govern people who are subject to the jurisdiction. So it ends at, well, it doesn't, whatever the numbers are, it doesn't really include anybody over 18, except to the extent that the offense was commenced in the jurisdiction, the juvenile court, and then isn't brought to final adjudication. And I have another question for you in terms of 72A. I'm trying to read it the way you're arguing, as you argued in your brief, but it seems to me another fairly straightforward application of 72A would be to begin in the juvenile court with a complaint, and then determine, because as you pointed out, it now encompasses 8-, 9-year-olds, right, and make a determination whether there's a discharge or not. And then after that, the complaint goes to, because it's by complaint, it goes in accordance with the usual proceedings. And then there were two references to other statutes, and one of them is the bind-over statute.
Correct.
So that's, to me, it could be read, could it not? You begin in the juvenile court. You have the only jurisdiction that the court has is to conduct the transfer hearing, the new 72A hearing, and then either discharge or proceed in the ordinary course. You begin in the district court, and then if it's something more serious, not a complaint, but proceeding by indictment, you proceed by indictment.
Right.
Bind over.
To briefly address your first point about the language of Section 54 in the previous paragraphs, I believe those previous paragraphs only talk about having jurisdiction over a child. The legislature clearly made a distinction between using language child in those first paragraphs and using the language of person, which person refers to all adults. So I don't think there's an age cap there. And to address Section 72A, the language of that, if you look at Section 74, that's the statute that says if you're going to proceed by complaint, you have to start with a delinquency complaint. Section 74, if you look at the beginning of it, though, it says except as hereinafter provided in this set of statutes, and one of those is Section 54. So I think that the legislature created this out where it says Section 54 is excluded from this requirement. You need a delinquency complaint to proceed by criminal complaint. And I'm not disputing that, but you don't have to proceed by delinquency complaint because, again, Section 74 says except in hereinafter provided.
In Porges or Porges, now, there was a hearing, right? I mean, is it just you say that it wasn't necessary?
In Porges, it almost supports the Commonwealth's position. In Porges, the defendant was 13 when he was charged with rape and a couple other crimes. And since he couldn't qualify as a youthful offender because he was under 14.
Oh, I see.
So essentially, Section 72 or Section 54 creates kind of this safeguard for defendants who are very young when they commit the crime, under age 14, or for fairly minor crimes, crimes that aren't felonies or aren't violent felonies, things that don't fall inside youthful offender. Then it gives the judge discretion to determine whether it's in the public's interest. But I think the legislature already determined it's in the public's interest to proceed against these defendants as youthful offenders.
One more. I'm going to show my lack of knowledge, but with this particular defendant, the time frame seems to me goes, well, from August of 98 to either 99 in one case or 2000, I forget, but somewhere between 15 and 16 and 20.
Correct.
So if, as a practical matter, could you just proceed in adult court and just start at the point when he's no longer a juvenile? I mean, charge him that way?
Well, he would be charged as a youthful offender.
No, but I'm just saying because he got all the way up to 20, right?
He did. So some indictments were for
Yeah,
crimes
so
he
I'm just,
committed as
I
an
mean,
adult.
is that, or do you need to go back? I just don't.
I think it could be tried in juvenile court, and I think in juvenile
Or it could be tried in adult court from the beginning, right? If you just forgot about 15 to 17.
Correct, but I think, again, this could be tried in juvenile court, and regardless, even if it was tried in superior court, these youthful offender indictments, if he was found, he wouldn't be found guilty, he would be adjudged or adjudicated a youthful offender. And again, we have to look at this as being liberally construed to not be a criminal proceeding. And if you proceed under Section 54, again, it's a juvenile court judge in juvenile court. It's not a conviction. And if we have to look at it just not for the defendant, but all these defendants who fall into this category, most of these defendants will be between the ages of 18 and under 21. It's the rare case that defendants are caught 20, 30 years down the road. And for these defendants who are between 18 and 21, a judge under Section 54 has the discretion to sentence or to commit the defendant to DYS or do a combination sentence of DYS with a suspended sentence. And so instead of doing prison time, he can be committed to DYS.
Or to sentence as provided by law.
Correct, but it also gives the judge discretion where there's no discretion when it's an adult conviction. And also there's several collateral consequences that follow from an adult conviction where it doesn't follow with an adjudication. Registration as a sex offender can be waived by a judge when it's an adjudication of a youthful offender, where it can't be for an adult conviction. An adjudication is not considered a conviction federally. For adjudication as a youthful offender is not considered a conviction for federal immigration purposes.
That makes sense, but where the legislature has specifically already identified a category of juveniles, 17 to 18, as being treated as though they fall within everything under the jurisdiction of the juvenile code, why wouldn't the legislature have said what you're saying, instead of saying what they did say, which on its face looks like they didn't intend to do anything except to keep jurisdiction over the transfer hearing and then send a person over the age of 20 or 21 or even younger on their way into the criminal system.
I think
or
it
not.
Is, I think it is clear the way they did it, especially when you read it in conjunction with Section 53, where Section 54 needs to be liberally construed to not be a criminal proceeding, and essentially Section 50.
But isn't the point that Justice Duffly's making is that you're not foregoing 54 if you have a transfer hearing under 72A? It's just a first step, right?
I think the defendant's argument is Section 54 is inapplicable because the only jurisdiction over these defendants is Section 72A. And 72A specifically does not, or excuse me, Section 54 specifically does not require compliance with Section 72A.
You're arguing two things. One is we really want to take care of these youths and extend to a now adult who's 28 the benefits of what he might have benefited from had he been younger. And the other, probably equally important thing is we don't think it's up to the juvenile court judge to discharge, even if, right? We can bypass. So, but there's another provision, 263 Section 4, which says no juvenile shall be sentenced, that is, as compared to committed, to any punishment as provided by law, except as otherwise provided by 72A. And I'm not sure how to reconcile that.
I think here that would be trying the defendant in I don't want to use the phrase adult court, but a district court or superior court. Here, again, this is an adjudication. This isn't a criminal proceeding. These youthful offender proceedings are not criminal. So I think that's where the difference is. And again, we have to look at this as liberally construed for the benefit of the defendants, but we also have to take into account.
But they could get up to a life sentence as a youthful offender.
They could, but again, there's no discretion for the judge like there is for a adjudication of youthful offender, where there can be a DYS commitment or a combination sentence of DYS with a suspended sentence.
Ms. Foster, I want to ask you a question to see if I understand whether the district attorney has an option in these circumstances. And my question assumes these facts. If a rape is committed and the assailant is, the perpetrator is unknown, but there's a DNA sample, and then years later, there's a hit on the DNA in the system, and it turns out that the perpetrator is now 50 years old, but at the time the crime committed, he was 16. Does the district attorney have the option of either proceeding against that person with a juvenile complaint and then going up the Route 72A ladder, or alternatively, indict him as a youthful offender?
To begin, there would be an issue of statute of limitations. If we're assuming that's not an issue here, yes, the legislature created two different paths for the Commonwealth to proceed down. One is if the Commonwealth chooses to go by district court or superior court, most likely, and have an adult conviction for this person who was a juvenile when the crime was committed, yes, then a 72A hearing is needed. But on the other hand, if the Commonwealth does not want to proceed against this person as an adult and chooses to proceed against him as a youthful offender, then there is no requirement.
But the person the defendant would have an option, or the defendant would have an opportunity under the Section 72A to a judge's determination that it's not in the interest of society to proceed against him, whereas if he were charged as a youthful offender, that opportunity would not be available.
The purpose of the 1996
Act...
Is
that a yes?
I believe either path could be proceeded down. I think the purpose, though, of the 1996 Act was to close these loopholes and to provide for more prosecutorial discretion. I think if we eliminate Section 54, that eliminates one of the purposes of the 1996 Act, which was to proceed against the most violent of criminals. And here, in your hypothetical, Your Honor, it's someone who committed a rape, which is obviously a violent felony, and so they can be proceeded against as a youthful offender. If there are no further questions, the Commonwealth will rest on its brief.
Thank you.
Good morning, Your Honors. May it please the Court, my name is William Smith. I represent Mr. Nanny in this matter. My sister said something. She said that the purpose was to close all loopholes, that is to say the amendments effectuated in the 1996 Act. That's just the problem. That's not what the legislature did. In fact, the legislature, I would suggest very carefully, very deliberately, considered changes to this whole statutory framework, to these procedures. And the fact of the matter is they did not in any way, shape, or form amend, change, repeal.
Well, but 54 doesn't make any reference to 72A at all. It just says in accord with sections 55 through 72.
Correct.
They
But
can be proceeded against by a youthful offender indictment,
Well, but that, I would suggest that's precisely one of the problems. The fact is that Section 72A, Your Honor, is there, and I would suggest it is, as Justice Duffly alluded to, it is the threshold jurisdictional requirement
Well, let
that
me
in
ask,
these cases.
let me ask this, because I honestly don't understand how these pieces are supposed to work and how they do work at this juncture. Somebody has committed a violent crime between ages 14 and 17. I take it that up until his 18th birthday, the Commonwealth can proceed to indict him as a youthful offender, right? Doesn't need any permission of any court anywhere.
Assuming he was apprehended.
Well, oh, well, that's interesting. So he could, if he's indicted but not apprehended?
Well, I hear what, yeah, I understand your point, Your Honor. The problem is the salient consideration is the fact that we still have Section 72A. It was not amended. It was not repealed.
All right. So he can be in, well, if he's apprehended. No, I don't really understand at all. But okay, let's assume he's apprehended and indicted one day before his 18th birthday. All right. No, there's no hearing, no 72A hearing, nothing. He's indicted as a youthful offender. He goes through the youthful offender process.
Correct.
He's age 18 and a day. The Commonwealth loses the power to indict him as a youthful offender and has to go through, proceed down
I
to 72A.
don't suggest they would lose the power. The fact is they would have to first proceed under 72A. Now, that might be odd. It might be unorthodox. It might be perplexing. It might be strange, Your Honor. The fact of the matter is it's what the legislature did.
So if under 72A the judge then says, well, yeah, there's plenty of probable cause here, but I don't think it's in the interest of justice to proceed, that's
Correct.
it.
Correct.
That's it.
That's
Prosecution cannot indict, even though they could have indicted 2 days before.
Correct. The Commonwealth, Your Honor, would have the ability to have some sort of appellate review. And, of course, the standard essentially would be whether the judge abused his discretion vis-a-vis that second prong. But the fact of the matter is, Your Honor, it's the law. It's what the legislature did here. There might be a situation here where maybe the legislature should wish to address this. But it certainly, of course, is not for this court to go about doing that by way of adjudication.
So I think I was wrong before. If I look at 72A, okay, 72A in that hypothetical applies, and you say if the judge doesn't think it should be dismissed, then doesn't the judge have to dismiss the juvenile complaint and have the Commonwealth proceed with the person as an adult?
The Commonwealth could proceed by complaint or by indictment thereafter. And
But,
in fact, 72A
criminal
references the
complaint.
traditional. Correct, Your Honor. 72A
so
then
you
goes
are
on.
in adult court. You
Correct.
cannot be in juvenile court.
Correct.
Correct.
In fact, 72A then goes on, I believe, at the end of the section, at the end of the statute, to simply address the traditional adult
Guilty plea,
procedures.
right.
Yeah, okay.
And so, although it might be unorthodox, although it might be sort of a quirky thing, for lack of a better term in the law, it's the law.
Is there
It's
any
what the
legislative
legislature has done.
history on this?
I'm sorry, Your Honor.
Legislative history.
To the extent I looked, and to the extent that I looked, I found nothing in terms of, relating to what Justice Cordy's question, was getting at. But I think the fact of the matter is the case law
When they did the 1996 laws,
amendments to.
yeah, nothing there about this particular situation.
Correct. Nothing that I saw. And the fact of the matter is, of course, this court has repeatedly said that the fact that other procedures were addressed in this statute, or the fact that certain provisions are included in a statute, necessarily means that we can infer that the legislature meant to exclude others. There's a Latin term for it. It escapes me from law school. But the fact of the matter is, I think that's what we're left here with. And if the legislature wishes to address this anomaly, it's free to do that. But the fact of the matter is it did not do so. And I think it's precisely because of the fact that the legislature addressed the issue of eliminating individual adjudications for more serious offenses. In other words, it used to be the case that apparently that these transfer hearings would be done on a case-by-case basis. The legislature said no more with respect to these certain categories, these certain offenses. That is no longer the case, and that was certainly their right to do that. But the fact of the matter is, at that same time, they easily could have changed this to say, well, at least in cases where there's a youthful offender issue or youthful offender offense involved, we're going to obviate the 72A process. They did not do that.
So carrying through with Justice Cordy's scenario, if the person commits the offense at the age of 16 and is indicted as a youthful offender, but for whatever reason is living with his grandmother in Alabama and is not picked up until he's 18 and 1 day, he loses the opportunity then to be charged as a youthful offender.
No, I don't agree with that.
The fact of the matter is, how would it work?
Because he hasn't been apprehended before he was 18.
He hasn't been apprehended, but the 72A procedure would apply, and then after that, a complaint would be issued, and/or the Commonwealth would then proceed by indictment.
So your view is that under 72A, when the judge says, I'm not going to discharge it, it's too serious a crime, but I thought 72A says that you must dismiss the juvenile complaint.
Correct. I mean, correct.
And cause a criminal complaint.
Correct.
So
I'd like to say yes, Your Honor. I would love to say yes, but that's not what the legislature said.
But the fact of the matter is that this kid, because he was in Alabama, but if he had been picked up 3 days earlier,
correct,
he would have it.
That's what the statute results in.
And there's nothing that permits the kid to say, thanks, but no thanks. I actually would prefer to be proceeded
I'm bound to say my reading of this statutory paradigm is no. There is no such. I mean, it simply is not in the statute. And so, but we can't, by decisional law, sort of, seek to rectify that, because the fact of the matter is the legislature very carefully considered. It was before I graduated law school, but I do remember a lot of discussion on that. Very carefully considered this entire scope of juvenile procedure and did not.
So I'm just, I find this almost incomprehensible, but obviously somebody knows how it applies, or I guess that's why it's here, because we're not quite sure how it applies.
We're trying, Judge.
All right, so we've got the youthful offender indictment. Person is 16, is indicted, but he's not arrested until he's 18. So what's before the court? 72A talks about a delinquency complaint being dismissed, but there is no delinquency complaint. There's a youthful offender indictment.
Well, but, Your Honor, 72A starts out, the case of any person who commits an offense prior to his 18th birthday. So it does not draw that distinction. It's
but it talks about what the court is to do is either to dismiss the delinquency complaint. There is no delinquency complaint here. There's a youthful offender indictment. So does that mean the court would dismiss the youthful offender indictment?
There was a complaint initially. So the fact...
Does there have to be? Can the Commonwealth just indict directly?
Of course, that's the whole issue.
No, I mean, can the Commonwealth indict directly a youthful offender?
Yes, it can. Under 54, it can.
Right.
Well, under 54, but that doesn't...
So we have a pending indictment, properly brought, against a 16-year-old, timely brought before their 18th birthday, but they haven't been able to apprehend them.
In that scenario, I'm sorry, I thought you meant in the other scenario. Absolutely, absolutely. So it's an anomaly, Your Honor. I'm not disputing that, but it would be something the legislature would have to address.
No, but take that example. What happens under 72A? Because the 72A only talks about complaint. What happens to that indictment?
Well, if it happened before, if he was apprehended before...
No, he wasn't.
If he's apprehended after...
What's pending is an indictment.
Correct.
So
I would suggest you would have to... It's a threshold jurisdictional requirement in 72A, and so therefore it would have to be preceded by way of complaint, and then thereafter, if the Commonwealth sought an indictment, they would be free to do that because it references the adult procedures.
So the youthful offender indictment, which would have been properly brought, becomes a nullity at 18. Nullity. It's actually not processed.
Under these statutes, I don't see how any other result is possible.
Well,
it simply is
you
not
could
addressed.
read it the way that Ms. Foster does. You could say that 72A
and the
doesn't
Commonwealth
apply.
is also arguing and saying essentially that regardless there was a probable cause determination made in the grand jury indictment, which of course it's not the same thing. The defendant at that point has no right to cross-examine witnesses, to present evidence, or a right to counsel or anything of that nature, for one thing. For another thing, then, the Commonwealth is saying that as to this particular offense, the legislature has already made a determination of dangerousness. But that's not what 72A says. 72A clearly contemplates an individualized adjudication as to whether or not the complaint
72A
should go.
amended at all in the 96 rewrite?
No,
It was.
no. So it may very well be the case that this is something that the legislature arguably should have addressed at the time, but they simply didn't.
72 has some role here, right? Section 72. I mean, it speaks in terms of continuing jurisdiction, and in that section you're talking about indictment versus apprehension, and it says if the Commonwealth has proceeded by indictment, although it speaks in terms of juveniles who commit the offense prior to 17 and not apprehended until between 17 and 18. So you could argue that
Cover
that
that
cuts it, right? If
situation
you're
anyway.
apprehended after that, you're out.
Correct.
So just clarify this for me. When you're speaking of proceeding by indictment, and the Commonwealth used this term, I think there's direct indictment, that is indictment in the juvenile court, right? That's one way of looking at indictment. And the other way, because it emanates from the grand jury, and then you bring it in the juvenile court, the other way is indictment that isn't brought for trial in the juvenile court. You just leave it there. So is that correct?
I think it is.
So when you speak in terms of 72A about proceeding by complaint, it's the complaint that initiates, because you
Correct.
need something. You don't have a standalone motion, I take it, it's
Correct.
possible.
Correct.
You proceed by complaint to have a transfer hearing because there's nothing pending.
Correct.
That's one way of looking at it, because it doesn't fall within 72.
Correct.
Okay. So just to clarify, because I hear it, and I'm not sure we're talking in terms of the same kind of indictment and proceeding.
Correct.
Can the Commonwealth skip the 72A, take the indictment they obtained against the person now 28, and bring it to trial in Superior Court? You're saying no.
Correct.
Okay.
Because again, it just comes back to that being and the case law confirms it is in fact a I would suggest a subject matter jurisdictional requirement.
So they
It's
go through
just-
the hearing, and then if it's not discharged, then they can go in the ordinary course.
Correct. So it really is best seen as a sort of gatekeeper
Okay.
mechanism, as it were, Your Honor. And the fact of the matter is, the Commonwealth might not like that, but with all due respect, for that to be rectified, it would have to be done by way of legislative action.
Now, pragmatically, with regard to your client, if you prevail here, is it your view that the Commonwealth is barred from proceeding against him now with a juvenile complaint and proceeding to a 72A hearing?
Well, they would have to go back. The fact of the matter is the judge here already dismissed it, so it would have to go back to that 72A hearing. I believe as well, Your Honor, that your question is going to the fact is the record indicates that at least as to one or more of these offenses, it was committed, after he was 16. It's a little bit muddled. But the fact of the matter is, it would have to be a 72A hearing.
Okay, but I mean, but this is without prejudice, I assume, that your client could still be prosecuted even if you prevail here today.
I'm not aware of anything that would prevent that. But the fact of the matter is, it would have to go back to that gatekeeper function.
Right, but then it could happen, and then he would be prosecuted in the Superior Court.
That's
an adult.
Assuming that the 72A panned out that way.
Right.
If there are any further questions, I'd be happy to answer. Thank you very much.